Good afternoon, everyone. Welcome to UpStart Live by PayU. I'm Mancha, your host for the evening. So, PayU, as you know, is one of the leading payment service providers. We are across sectors like airlines, SMB, and of course the startup community. So, UpStart Live is a series where we run sessions around topics of various importance to entrepreneurs, founders, and startups. So, we usually bring in experts, subject matter experts like Radhika here to talk about various topics. Today's topic is around legal nuances in e-commerce. So, Radhika, before we go into the topic, would you like to just start off with your background, a little bit about what you do, and why are we talking today about legal nuances around e-commerce, right? So, over to you. Thank you so much for being a part of today's session. And for everybody's information, um, Radhika is one of the few people as speakers that we go back to because we realized she has a lot of knowledge to share around anything legal, anything law, and we want as many people to be benefited from this. So that is exactly why we keep bringing Radhika back to our session. So please, Radhika, go ahead. We can start talking about this.
Perfect. So thank you so much. Thank you, Mansa, and thank you, PayU, for giving me this opportunity once again to do what I love doing the most. That is engaging with people and sharing information about certain aspects of law, which a lot of entrepreneurs have questions around. And to begin with, let me give you a brief background about myself. I'm Raddhika Singh, and I'm the founder of Aletheiaa Legal. It's a law firm that specializes in intellectual property, information technology, data privacy, corporate laws, and POSH related matters. I've been practicing for 16 years and I started my firm 8 years back. And I have advised over 350 startups, and this is the space that I really enjoy being in. And the reason why, Mansa and I were just discussing, and we were wondering that what are the topics that we could cover now, and what we realized was that given the pandemic and what a lot of businesses have gone through, majority of them want to go online. They are offline and they want to bring their businesses online, and they have questions around it, that how should they go about it, what are the compliances they have, what are the laws they need to be keep in mind. So we thought, let's have a session around e-commerce and the legal nuances. So today we are here, and we'll be having a conversation where we've thought of certain issues, where Mansa has come up with certain issues that we'll be discussing. And at the end of the session, please feel free to ask as many questions as you have. So yes, Mansa, over to you.
Thank you, Radhika, for giving that background to the whole conversation. Like Radhika mentioned, we have a few questions for the speaker, but please feel free as the audience to post in more questions. Radhika will be able to pick it up, uh, and we will be able to answer this for you. So, um, Radhika, just wanted to ask you a few things around again e-commerce, right? So, and the legalities behind it.
Yeah.
So, starting with the first question, if somebody wants to start selling their products or their services, render their services through their website, then
Hmm.
what legal aspects that one needs to remember and follow when they are creating the website itself, right? Like, what is the
Okay.
first step that they need to do before even starting off with the website when they are creating?
Got it, Mansa. So that's a very important question, and that is something a lot of people when they're starting off ask. And what they need to keep in mind. See, when we are building, you're creating your website or you're launching an app. Basic requirement is that your consumers, it's easier for your clients and your consumers to purchase your products or avail of your services. Now, the first step that we generally advise startups or people who are taking their businesses online is, most important is identify your intellectual properties. You need to see that when you go online, it's basically your brand is accessible and your products and services are accessible to people all across. And what you need to be aware about is that the brand that you've looked at, the name of your website, the domain, the products that you're offering, or the services you're offering under a certain business, have you obtained a registration for that brand, or have you done the due diligence to identify whether that brand under which you're offering your products or services, or the domain name that you have purchased, does that infringe any third party IP? You need to be very particular that it does not infringe anyone else's trademark, that there's no confusion in amongst your consumers or your customers or people who avail your services, that are they availing your products and services or it's some other entities. So first is identify what is the brand name that you're going to look at under which you're offering your website, or you're offering your products and services on your website. Second, only if that brand is available, then book the domain. A lot of people first book the domain, pay a huge amount for it, then they do a trademark search and realize that the brand is not available, and then they can't do anything. Second is, there is a misconception that people have that even if you add a .com or .in in front of a domain, it makes a huge difference. No, it does not. The what is important is the brand that comes before, like between www dot and .in, that is the end part, which is the middle part. That's the most important, because that's your brand and you to ensure that it does not conflict with any other party's trademark. That's one aspect. Second is, you need to see that if you have got your website developed by a third party, or you've given it to a software developer, you need to ensure that the website has been developed for you and all the IP in that vests with you, the source code vests with you. That are important aspects that need to be looked at. If you have outsourced the branding, that the logo that you have, if that has been developed by a third party, you have proper agreements that while they have developed your logo or while they have developed your software, they have not infringed or used any third party content. Now, I know these may seem as, no, they will not, but no, it's important to ensure that you have those kind of agreements to protect your rights. And these are some of the basic things that you need to keep in mind from an IP perspective. When you are launching your website, you also need to be particular about the fact that the content that goes in developing your website, that content does not infringe any third party IP. A lot of people, when they're creating an e-commerce platform, they look at the platform of their competitors and they will copy certain content from there. That amounts to copyright infringement. So you need to be particular about these things, that in a hurry you do not go around infringing any third party IPs, and then before you start the business you face a lawsuit. So the third aspect is, when you are selling your products or offering your services offline, a lot of times we have agreements that we enter into, or our clients will want to enter into agreements with us. Now, similarly, when you're creating your website or you're launching a mobile app, there is a contract between you and the people who are going to be buying your products or availing your services. These are e-contracts, and in the e-commerce world, they will be called your terms of use or your end user license agreement. They have different names, or terms of service. These are basic agreements which you enter, or a contract that you enter between with the owner of the website or the app and the end user, and these govern.
Raddhika, just coming in between this, just asking you, I think in case our audience is just joining us right now, I see some of them have just joined.
Yeah.
Does it happen in the beginning of the whole conversation with like whole building the website, or does it come somewhere in between, or when it's in the end?
Okay, so the conversation when you're developing the website is the part where we're talking about you entering into agreements with your website developers, people who are developing the website for you, people who are developing the mobile app with you. You enter into agreements with them to safeguard any content that they've created and ensuring that that belongs to you and that they've not infringed any third party IP. This is in the beginning. Identifying your brand or your purchasing your domain name is obviously right at the beginning, and these work simultaneously. And once your website is ready, then you, before you launch the website, you need to have your terms of use and privacy policy that are uploaded. And your Play Store and Apple Store will not allow apps to be onboarded till the time they have terms of use and privacy policies in place. So these come at the last. And these, like I said, are the agreements between the owner of the website and the end user. Yeah, Mansa.
Understood, Radhika. That makes sense. So again, while we understand all the what needs to happen behind the scenes, right? What are there any specific guidelines, like legally, any guidelines for operating e-commerce businesses in India? It doesn't matter how big or large, how small scale or large scale the whole operations might be.
Yes, Mansa, the thing is, there are laws in India. So, some of the laws that are prevalent, and I will be, talking about some of those because it's important for people who have the e-commerce business to understand those. Main laws are the Consumer Protection Act, and under the act, there are rules which are called Consumer Protection E-commerce rules that came out in 2020. Then e-commerce entities also have to comply with the Information Technology Act of 2000. And under those acts, there are certain rules which govern the how the marketplaces or how intermediaries, what is it that they need to comply with. So I will be going through those and I'll try and simplify those as much as I can. And so if we look at any, you asked me that are there any specific guidelines for operating e-commerce business in India? Now, yes, most important law that is there is known as the Consumer Protection E-commerce rules, which got notified in 2020. Now, as per those rules, I'll be highlighting some of the important aspects of those rules. First is, a lot of people want to know what is an e-commerce entity, who falls within that. Now, as per the rules, e-commerce entity is any person who owns, operates, or manages digital or electronic facility or platform for electronic commerce. But it does not include a seller who's offering his goods or services for sale on a marketplace e-commerce entity. So it includes an inventory e-commerce and a marketplace e-commerce. So just to simplify it, if I am a merchant and I want to sell my products online and I create a website where through that website I have an inventory of my products and I sell those products, I become an inventory e-commerce entity. Okay. Now, if you have something like an Amazon or a Flipkart, which is like, or which is a marketplace, that becomes an e-commerce marketplace. And under the consumer protection e-commerce rules, there are different rules that are applicable to an e-commerce entity in general and specifically to an inventory e-commerce entity and to a marketplace e-commerce entity. So if we look at it, the first and foremost thing is that who all come within the purview of the consumer protection e-commerce rules. Now, it is applicable to anyone who's selling goods or services, a platform where goods and services are bought or sold over digital or electronic network, all models of e-commerce, including marketplace and inventory models, and all e-commerce retail. So each and every person who sells their products online through their own website or through marketplace comes within the purview of the consumer protection e-commerce rules. And what is very important about these rules is that it is not only applicable to an entity which is established in India, but it is also applicable to entities which are not established in India but offer their goods or services to consumers in India. So that is how broad these e-commerce rules are, and they clearly highlight what are the duties of an e-commerce entity. Which means if you are looking at selling products, you are a merchant and you want, or a service provider, and you're looking at offering your products or services directly to your consumers from your website or a mobile app, these are the details that you have to mention, which is your legal name, that is the business name or the company details, the geographical address of where your headquarters or your branches are located, name and details of your website, if any, and contact details like email address, fax, landline, and mobile numbers of your customer care and the grievance officer. Now, second mandatory provision is that every e-commerce entity has to appoint a grievance officer. Now, this grievance officer is basically for addressing or redressal of consumer grievances, and every e-commerce entity has to display the name, contact details, and designation of this officer. And it is mandatory for this officer to acknowledge any complaint that they receive within 48 hours and redress the complaint within 1 month of receipt of the complaint. Now, this is a mandatory provision which every e commerce entity has to comply with. So, it is mandatory and it is not optional. You know, a lot of people come to me and say, why do we have to appoint a grievance officer? We are just two, three people in the company. Is it mandatory for us? Yes, even if you're just two, three people, you have to appoint a grievance officer because it's a mandatory provision under the Act and the rules, Consumer Protection Act and the rules thereunder. One interesting aspect that have been covered is no e-commerce entity shall impose cancellation charges on consumers canceling after confirming purchase unless similar charges are to be borne by the e-commerce entity if they cancel the purchase order unilaterally. So you can't just say that there'll be cancellation charges if you're not going to be paying those if you were to unilaterally cancel the order. Then there is another provision which says every e-commerce entity, you know, generally what we've seen is that when we go on a website, there are terms of use, privacy policy, and you just have to tick a checkbox and say, I have read it. Now, these rules have brought in something new. They're saying just getting consent of a consumer by the form of a pre-tick checkbox is not enough. They say every e-commerce entity shall, that means it's mandatory, only record the consent of a consumer for the purchase of any goods or service offered in its platform where such consent is expressed through an explicit and affirmative action. And no such entity shall record such consent automatically.
Radhika, you might need to sort of speak of uh, this particular clause in simpler terms so that the audience understands.
I'll do that. Of the explicit consent, or the basically the what is applicable to them and what they have to.
What is applicable to them? Yes, like where
I'll
they stand.
Okay, so I will just tell you these. So, what it basically says is if you are launching your website or you're launching your mobile app, what are the things that you need to do if you're an e commerce platform? Is you have to clearly tell the consumer what is your full company name. What was happening is, which we'd also noticed, is a lot of companies have their website, but nowhere on the website do they clearly identify the full name of the company, the address of the company. If the consumers have any grievances, who can they reach out to, who's the grievance officer, what is the number of the customer care, none of this was available. And as a result, if there was any fraud or if there was any complaint that a consumer had, they had no recourse. They did not know who to go out to. So, to ensure that such instances do not happen, the law has made it mandatory for the e commerce entity to mention all these names: your company name, the registered address of the company, where all are your branches located, the number of the consumer customer care, as well as a grievance officer. Now, these are some of the things which all e commerce entities have to comply with. Now, you may ask me, who's a grievance officer? Grievance officer is, suppose somebody finds a spurious product on the website, or they say that, you know, somebody has infringed, they are selling my products without taking my permission, or somebody has put up some content which is offensive. Now, who do they reach out to? For that, they will reach out to the grievance officer and say, this is the grievance that I have faced, and I want you to redress that grievance. Now, the only way that grievance can be redressed is if the website or the e-commerce, the owner of that e-commerce platform has listed down and given all the details of the grievance officer, such as their name, their phone number, their email address, and also the designation of that officer in the organization. And if you, when you appoint a grievance officer, it is again mandatory for that grievance officer to acknowledge receipt of any complaint that he receives or she receives from a consumer within 48 hours of receiving the complaint. And they have to redress or solve that complaint within 1 month. This is as per law. And cancellation charges is, if you're imposing any cancellation charges on your consumers after they have confirmed purchase, then what the Consumer Protection Act says is you cannot impose these cancellation charges if if suppose you were to cancel the purchase order, and if you were going to give your consumers any you were going to pay them for the cancellation charges, or if you were going to refund or you were going to pay a penalty, then you can, otherwise you cannot. And explicit consent is that, a lot of times when we go to websites, we see that, it just says agree to terms of use and privacy policy. We just tick on the checkbox without reading terms of use, and we have no idea what that entity has asked us to agree to. And a lot of e-commerce platforms will say we are not liable and our liability is restricted to a certain amount. And if something happens, we are not responsible for it. Those kind of things we tick without reading. So now, in order to ensure that the consumer is taken care of, the law has, what they basically said is that you cannot assume or presume that the consumer has consented by just giving a provision of a checkbox. You can't say I consent, that you consent to all the terms of use and you have to tick this checkbox. They're saying that's not enough. You need to take an express consent through an explicit and affirmative action. What some people have started doing is, while they have the pre-tick box, they say, okay, you're ticking this box, but before the consumer is going to purchase a product or avail of a service and pay for it, they put another pop-up that comes up which says that by clicking this or by purchasing this product, you are explicitly agreeing to be bound by the terms of use of this particular website. And then they again give a link to the terms of use so that the purchaser has read the terms of use. So that could be seen as an explicit consent that they have obtained from the consumer. So these are some of the provisions that are there, Mansa. And some of the other things which they've also stated is that every e-commerce entity has to provide accurate information relating to the return of products, refund of products, exchange, warranty and guarantee. Will they be charging for delivery and shipment? What will be the process for refund? What will be the cost of return shipping? All these have to be clearly mentioned on the website. Earlier, even a vague thing was okay, that the refund policy will be as per the terms of the company, but it did not clearly identify what that policy is. Now everything has to be clearly mentioned. How will the return work? Within how much, within how long will the return happen? Within how long will the refund happen? If there is an exchange, what is the process? What is the warranty and guarantee that the e-commerce entity is giving regarding its products? What is the delivery and shipment time? What will be the cost? All that has to be mentioned. And a total price has to be given in a single figure of any goods and service, along with the breakup for that goods or service. They have to mention what are the delivery charges, if there are any postage and handling charges, any conveyance charges, what are the applicable taxes, need to be clearly identified. So these are the provisions that are relating to e-commerce entities where in people are selling, where the merchants are selling their own products through their websites. And they also apply to e-commerce marketplaces, but there are also specific guidelines for e-commerce marketplaces.
I was actually just coming to that question. Now, spoke about what happens to these e-commerce merchants, right? Like, uh, what are the things that they need to keep in mind? What are the guidelines for them when they have to operate here? What are the specific guidelines for these marketplaces? Then must be different, obviously, because
Yeah. So Mansa, the what I told you in the above, what I was sharing about duties of an e-commerce entity, that is applicable to all e-commerce entities, whether they are institutional, whether sorry, they are inventory e-commerce or they are marketplace e-commerce. It is applicable to all. In addition to what I've already shared, especially for e-commerce marketplaces. Now, first of all, what are marketplaces? These means an e-commerce entity which provides a platform on a digital or electronic network to facilitate transaction between buyers and sellers. We have so many marketplaces in India right now where they connect a buyer with a seller. Now, these e-commerce marketplaces are also known as, they also play the role of intermediaries. I'll go to that later. But as as far as the e-commerce rules are concerned, in addition to what we've said above, every marketplace has to provide details about the sellers. Who are these sellers offering goods and services, including the name of their business, whether they are registered or not, where are they registered, where are they, the geographical address, where are they located, the seller's customer care business, and any rating or other aggregated feedback about such seller. If they have any ratings about the sellers, those have to be those have to be displayed. Any other information necessary for enabling consumers to make informed decisions, all these aspects have to be provided very clearly by the e-commerce marketplace. They have to say these are our sellers and these are our contact details, these are their contact details, these are their ratings. If anybody has filed any complaint against them, those things have to be clearly mentioned. If they've been recognized or they have got a very high rating, those have to be mentioned. Any feedback relating to them, those have to be clearly mentioned. Why? So that when the consumers are buying the products or availing the services, they can make an informed decision. So these are all being brought in to ensure that the consumers are taken care of. So these are the obligations that e-commerce entities have to comply with, and especially marketplaces. Again, the marketplaces have to provide detailed information relating to return, refund, exchange, warranties, delivery and shipment, redressal mechanism. All these need to be clearly mentioned by e-commerce marketplaces. Now, there are many more compliances by the marketplaces, but I don't want to go too much into that detail. But yeah, what I've already explained earlier, and these are in addition. And see, under the IT Act, the intermediaries are basically given a safeguard. Okay. If it is an intermediary, someone who is just storing information for a certain period of time and they're just connecting people, okay, if I put it in layman language, and marketplaces become intermediaries, okay, and they basically what they do is they say, see, we are just providing you a platform where we are giving you an opportunity, that is the buyer and the seller, to interact with each other, okay, but if tomorrow the seller wants to complain against the buyer, we are not responsible, because we are responsible only for providing that platform to you. Now, there are certain guidelines which are known as the Information Technology Intermediary Guidelines Rules 2011 and 2021, which are applicable on intermediaries, which also say that these intermediaries have to be particular about certain information, and they can't just say they have to conduct some due diligence. The intermediaries, who are mainly marketplaces or aggregators, have to publish on their website and their mobile app terms of use privacy policy, where the buyers and sellers will use the intermediary's website, and the terms and conditions have to contain, they have certain mandatory clauses that need to be incorporated in the terms regarding hosting or uploading or modifying of certain information on the e-commerce platform. And one of the major requirements is that if I'm an intermediary, if I'm an Amazon, okay, and I'm allowing people to come and sell products on my platform, I need to ensure that in my terms of use with the sellers, I clearly mention that you cannot upload any product which infringes any third party IP. You cannot upload any content which is seen as being defamatory, which is seen as being obscene, which harms minors, or which basically threatens the security or the integrity of the country, or which goes against morality. These are some of the clauses that are mandatory and have to be put in on each e-commerce platform's terms of use and privacy policy, where they need to show that this is the due diligence they've given. They have told the sellers that you cannot sell anybody else's products and say it is yours. You cannot infringe any third party IP. And if anything like that comes in, we will pull down your page, or we may even block you from the website. Or even where they are uploading, like YouTube is there, YouTube is very particular. YouTube will say that if you're uploading any songs or you're uploading any performance, that it is your own creation and you're not infringing any third party IP. Or any performance that you're putting up should not defame anybody. It should not be obscene in any manner. It should not go against the integrity of the country or the sovereignty. These terms have to be incorporated in every terms of use. And if the intermediary, or if the if the intermediary is informed by a court of law, or they get an order from a court saying that there is certain information that is available on your website that needs to be pulled down, and then they have to assist the government agency or the government, and they have to remove and disable such information asap, but within 36 hours of knowledge. They have to pull it down within 36 hours of knowledge, and they have to preserve that evidence for 180 days. The other thing is also, if the intermediary is just collecting user information, then they have to retain that information for 180 days after the person has cancelled their account, or they have withdrawn their account. So these are some of the aspects that intermediaries have to keep in mind, such that they are not liable for any action or any issues that arise under the IT Act. These are some of the due diligence that they have to keep in mind when they're drafting or when they're uploading their terms of use and privacy policy. And yeah, so these are the some of the aspects, Mansa.
Sure, Radhika. I think that about covers it. I saw that there were overlaps between what is specific to marketplaces is also certain guidelines that are specific to these e-commerce businesses as well. So
Yeah.
that is something that I noted as well. Okay, now going to another question, right? What are the current laws? Now you said e-commerce companies are marketplaces are allowed to they are considered as intermediaries, and they are allowed to store personal information. So,
Yeah.
what are the current laws in India to safeguard this information, right? That consumers give to these merchants or intermediaries in certain places. So, how is that
Okay.
protected?
Okay, so the thing is that, as most of us would be aware, that the data privacy bill is still, it's still pending. It hasn't come out. So till now, the laws that basically safeguard sensitive personal information in India, as of now, are is the Information Technology Act, and under that there are specific rules, which are the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Information Rules of 2011. Now, these rules, what they basically say is that if you have an e-commerce platform, or if you have a mobile or a website where people access your website and mobile, and they enter some data while they're creating an account, it is mandatory by law for that organization who has that website or mobile app to comply with these rules relating to the sensitive personal information. So the question that comes in is, what is sensitive personal information? So sensitive personal information, which is collected by a company, a body corporate, or an intermediary, includes information such as password. Okay, when we're creating an account, we have a password, user details at the time of registration. A lot of entities, when you're creating, you're logging into the marketplace, or you're logging into a mobile app, you have to give your personal information such as your name, your address, your email ID. Personal information is anything where by that information people can identify you as a person. So they know, oh, this is the date of birth, this is the number, that means this is the mobile number, oh, it belongs to so and so person. That is personal information. Sensitive personal information, which are covered by these rules, are your password, because it's very sensitive. The moment people get to know about your password, they can access your data. Again, user details, such as where do you stay, your mobile number, they can reach out to those people. So again, this is sensitive information. Bank details, credit card, debit card details, these are again very important sensitive information. Medical records or biometric evidence or biometric information, these are sensitive personal information. This is also very important for healthcare companies which are creating any health apps, or edutech companies that are creating educational platforms, because they have data regarding children. And the health tech apps, or e-commerce entities have medical information, and they also store bank details or credit or debit card information about the users. Now, The only exception here is any information which is freely available or accessible in a public domain that does not get covered under and is not recognized as a sensitive personal data or information. Now, when you're dealing with someone's personal sensitive information, the e-commerce platform has to comply with certain mandatory provisions. The privacy policy has to clearly identify to the users what are the type of personal or sensitive information that is being collected. What is that collect? What is it that you collect? What is the purpose for which this information is being collected? What are the means and modes of usage of this information? Like, why are you collecting? You have to clearly identify that, okay, we will collect data regarding your personal name or your health records or your medical records because we are a health app, and we will be analyzing that data and advising you on the kind of maybe the exercises or the nutrition, those aspects that you need to take. So you have to clearly mention the purpose and disclosure of information, that to whom will this information be disclosed and why will it be disclosed. For example, if it is a, so let's take an example of a health app. Now if there is a e-commerce entity that's, or they've created a platform where doctors and patients and labs have come together. Now, what the entity will have to tell the users is, okay, we'll be disclosing your information to people who are our partners, such as the doctors, such as the labs, such as the clinics, or any other third party, such as so and so. They'll have to identify who are the third parties that will be disclosed to. This is extremely important and has to be clearly identified. Now, the users should also be given the permission to review and modify the information. They have to have the right to review and modify the information, that if there is anything incorrect, they modify it, because if it is not, they are not permitted, and any data or anything, any information is given to them, or any, suppose it's a health app, or they are giving advice and wrong advice is given, then the app and the owners will get into a legal trouble. So they should have the permission to review and modify, and the users have to have the option to opt in or opt out. That is, they have to have the option whether they wish to disclose their personal information or not. Now, these are the laws relating to personal safeguard personal data online, and it's a mandatory provision that any intermediary or marketplace or e-commerce platform has to comply with the international standard ISO IEC 27001 on IT security techniques, information security management system requirements, which have been adopted by the country, or anything which is similar to this. And these are, like I said earlier, mandatory provisions which every marketplace and every intermediary that is collecting sensitive personal information has to comply with. I know it was a lot of information and a lot of legal things, but I had to share these with you because these are some of the basic guidelines. The e-commerce guidelines also further go on to talk about gaming companies. They go on to talk about media companies. They go on to talk about social media companies like Facebook, LinkedIn, all these. Like, what do they have to comply with? But given the time, we can't go into all of that. But I just thought whatever the mandatory provisions, those I can share.
I think that all that is a conversation for a separate day. If
Yes,
we
it'll be too much otherwise.
Yeah, I think other than the numbers, almost everything other than the clauses, right? That I think that was where most of us might have gotten a little confused. But I think every other part of the conversation was very clear. We have understood this. I saw that there are no questions because we have basically been asking all the questions that requires being answered. So we have a few good people watching us and answering us whenever you have been asking certain things about the grievance officer and everything else. So that is good. And we
There's,
have almost come to the end of the session.
there's
Anything else?
one question. There's one question. Is this only in India? That was one question. So,
Yes.
yes, these are laws applicable to India. But just like India, many other countries have their own laws. For example, European entities, European companies have the GDPR policy, and the US has its own privacy laws, which companies have to comply with. So the guidelines that I spoke about and the rules that I spoke about are applicable to entities that are doing business in India. And like in the beginning, I said, if there's any entity which is based outside of India, but they're offering their products and services to people in India, then the e-commerce rules apply to them as well.
Sure, Radhika, that makes sense. So thank you so much once again for being a part of the session. We did have a few, I think, glitches in our system before we started off on this conversation. So thank you so much to all the audience who waited to talk to us, and this has been wonderful. What we have seen that every time we have a new session, we get much more audience. We get very interactive people coming in, talking to our speaker as well as us about various topics, and also wanting to know more. So we will continue to have these sessions every time we can, usually once or twice a week. So please look out for updates on our next session on our LinkedIn page, or even YouTube for that matter. We also go live on YouTube. So thank you once again, Radhika, for doing this. It has always been wonderful whenever you come in as a speaker to our session. Uh,
Thank you.
we only know at the end of the session, we only know more about a certain thing than anything that we would otherwise have known. So thank you so much for being a part of this.
Thank
We look
you.
forward to hosting you again, and thank you to the audience as well. Take care.
Thank you so much, Mansa. And if anyone has any questions, please feel free to reach out to me, and I'll be more than
Radhika is
happy to
available
answer.
on LinkedIn. You can reach out to her in case you have any doubts. You can DM her, and she can respond to you if that's something that she can talk about. Or you can always go in for a consultation after, maybe that if that works. So please feel free to reach out with questions to Radhika on LinkedIn. Thank you so much.
Thank you. Thank you so much.